In February, Utah passed House Bill 392. It's a law that changes how constitutional challenges against the state move through the courts. Instead of a single district judge hearing these cases, the governor, legislature, or attorney general can now move them to a special three-judge panel, and any appeal goes straight to the Utah Supreme Court. Supporters say changes prevent single judges from blocking new laws. Critics say it shifts power toward the state and undermines judicial independence. To understand what this law actually does, I spoke with Elizabeth Wright, Executive Director of the Utah State Bar. House Bill 392 doesn't just change where certain lawsuits are heard. It changes who controls the path of constitutional challenge in Utah. For people who are unfamiliar with how courts work, it can be hard to see why that matters. I then asked Wright why this bill might be important for the people of Utah.
Its independence, impartiality, and fairness, and the rule of law are all central to our democracy. And we all learn that in school, and I think the latest round of bills has really brought it home that we have three co-equal branches of government, and our founders were kind of brilliant in not wanting power concentrated in one place. And all three branches are designed to check each other. And the courts play that role, and they check the two other branches of government if they don't follow the law or the Constitution. And then the remedy for the other branches is to either try to, if they don't like the ruling, either try to change the law or modify their behaviors so that it does conform with the law. And I think as all Americans, we have to be concerned with that. Even if we've never been to court, if we never think about the courts, they do impact our lives. And in order for our democracy to thrive, we need an impartial and independent judiciary.
Even after the bill was revised, the core changes remained the same. It gives state officials the power to move constitutional cases away from the judges and districts who would normally hear them. I asked Wright what the shift actually signals about how lawmakers view the courts and what message it sends to the public when the state can redirect a case to a different set of judges.
Well, what it does, it's been modified, and it's made a little better. But I think what it does is even now that it's been changed from a three-panel that the legislature would pick to a random panel. The legislature has been very clear that they don't trust judges in the third district for whatever reasons, even though they've confirmed and appointed them all. And I think they have this gut feeling that if they could get some judges from outside of Salt Lake City, they're going to get different results. And I'm not so sure about that, but they certainly think that they need to broaden who hears their cases and who's eligible to hear their case or cases against them, which are usually brought in the third district because most of the population lives here, the legislature's here. And what that does is it creates a public lack of trust in the judicial system, because what they're saying is not all judges rule the same. It's not fair and impartial. It's not independent, and we can game the system. If we could get judges from outside of Salt Lake City, we're going to get better results. And what that message it sends to the public is the system isn't fair, and you can set it up so you can game it and presumably get different results in different places, and it creates a lack of confidence in the system and sends the message that it's a political system that can, in a sense, be gamed.
With regard to moving a case to a three-judge panel, I asked Wright how that process works and what it means when only one side has the power to redirect a constitutional case.
So if it raised, and I know there's been a lot of changes to the bill, but the last I looked at it, okay. If it raises a constitutional issue, and then I think also they have this very vague language that the issue is of broad concern or something like that, the legislature, but not the plaintiff, can ask that the case be removed to this three panel. And they've also argued that three eyes on the case is better than one judge. And I don't know how this is going to work if there's a jury trial or they need to do fact-finding and evidence. But I guess the devil's in the details. Are going to work out later. Last I heard, the plaintiffs would not be able to request that it be removed to this three panel. It would just be the government entity that could remove it. And that raises issues of fairness and due process that might be challenged in court.
One of the biggest structural changes to House Bill 392 is the way appeals work. Under the new law, any case moved to a three-judge panel would bypass the Utah Court of Appeals entirely and go straight to the state Supreme Court. I asked Wright how that compares to the system Utah already has, and what parts of a case still have to happen in front of a trial judge before it can be appealed.
Well, I think, and I could be wrong, it's been a while since I've practiced in the courts. I think now it can't, like, for instance, with the redistricting, they had a trial court judge who found facts and heard, and then it did go straight to the Utah Supreme Court and skip the Court of Appeals. And so it can go right to the Supreme Court, but you still need a district court judge who is going to find facts, hear evidence, make a finding on the facts and the evidence, and then it can be appealed to the Supreme Court.
During this legislative session, lawmakers have introduced several measures that would change how judges are selected, how the Supreme Court is structured, and how cases involving the state move through the system. I asked Wright how House Bill 392 fits in with those types of bills, and whether those changes reflect something deeper about the legislature's recent relationship with the courts.
I would say that it's a solution looking for a problem. But I do think the legislature has had some very high-profile, high-stakes losses. There are a series of bills this legislative session, that whole handful of them that seek to make structural changes to the judiciary, adding judges to the Supreme Court, changing how judges are selected and retained, changing this whole procedure for essentially their cases. The cases in which they'd be a defendant. And I don't want to presume motive on anybody, but it's hard to say it's a complete coincidence after a series of losses that their interest in making all of these changes to the judiciary is organic. I think the timing is not a coincidence.
One of the main arguments behind House Bill 392 is that single judges can block major laws for long periods of time. This was a concern raised in an email exchange with TheLine.Info by Representative Matt McPherson, the main sponsor of the bill. I asked Wright to explain how injunctions actually work, why judges issue them, and what purpose they serve in constitutional cases.
It's pretty common, actually, and an injunction it's actually a very conservative, the rationale behind it is based in very conservative thinking that you maintain the status quo until the legal issue can be resolved. And there's a standard to receive an injunction. It's pretty high. The party seeking the injunction, one of the important things they need to show is irreparable harm. And the best example of it is, say they're going to tear your building down. And so you would seek an injunction saying, don't tear the building down until we resolve the underlying legal issue, because I win, but it won't mean anything because my building will be torn down, that kind of thing. Or death penalty is another example where I think my conviction was wrong and I'm about to be sent to the chair, and they're like, okay, we'll enjoin that so we can resolve the underlying issue without your being put to death. Those are the two easiest examples. I mean, they're not relevant here, but I'm just giving those as examples. The idea is that we hold the status quo until the legal issues can be resolved. And that's what happened here. The judge, in a couple of cases, and it's very standard when the stakes are really high like that and there's a big challenge that's a very complicated issue that's likely to go to a higher court for a final say from a Supreme Court, that a district court judge, the trial judge, will grant the injunction if the standard is met. There are two other prongs to that test, but irreparable harm is the main one, until the issue can be resolved. And it happens in federal courts and it happens in state courts, and it makes a lot of sense to maintain the status quo while we figure this out. In terms of how quickly the courts can function, that's a different issue that involves a lot of different things. Sometimes the case can be expedited. But he's not wrong. It does take a long time for a case to wend its way through the system.
Mm.
And it's kind of the price we pay as a society, that if we want to find truth and have a higher court rule on these really important issues, we're going to maintain the status quo until everything's resolved, till all the facts are found, till the law is analyzed, until the highest court speaks.
Another argument in favor of House Bill 392 is that having 3 judges look at a case is better than having just one. But in Utah's system, and in the federal system, panels are used at the appellate level, not at the trial court, where facts are found and evidence is heard. I asked Wright how panels normally function in the judiciary, and why applying that model to the trial stage raises practical and structural problems.
Well, panels are very common at the appellate level. Right? Court of Appeals, here's the Utah Court of Appeals, here's cases in panels of 3. The Supreme Court sits and hears cases, 5, soon to be 7 of them. The same in the federal court system, the United States Supreme Court, all of the judges sit. So the reason for that is when you have the case has been heard by a lower court judge who has found the facts, had a trial, or had it completely briefed, taken evidence, listened to witnesses. That's the district court's role, is to be a fact finder. They conduct the trial. They have witnesses sit in front of them. They have the evidence. They hear everything. And then by the time it gets to the appellate court, the facts have been determined, and the appellate court's job is to really dig down and think about the greater legal issues or constitutional issues. And it's really good to have a panel in that case. And the reason our system is set up like that at both the state and the federal level is because they're really complicated, meaty issues. And you have 3 people or 5 people or 7 people who really talk things out, argue, exchange ideas, and reach a result. Part of my big problem with this bill is that the lawyers I've talked to about this, they're kind of like, they're going to have a jury trial with 3 judges. How's that going to work? It just doesn't. Our system at both the state and the federal level does not work like that. You have one judge who oversees the trial, and they make the objections, grant or deny objections. They observe the witnesses, and I just don't know how they're going to have 3 judges at the fact-finding level. That's a role and a number for appellate cases. And I don't know how they're going to work this out. I don't know that they've thought that through, that they're going to have 3 judges sit there and hear objections. And are they, every time somebody objects in a courtroom, are they going to have to excuse themselves and go into chambers and decide, yeah, we're going to grant or deny this objection? I don't know. Or are they going to have to designate one of them to run the trial and the other 2 will just sit there? It's kind of unheard of. We just don't have 3 panels at the fact-finding level. And never heard of it. I don't know how it's going to work. We'll see how that goes. But then it goes back to my initial statement, too, where I think the purpose of the bill is they're hoping that different judges are going to find differently. And they're betting on that, and I'm not so sure. But I don't know how they think that 3 people sitting there listening to a witness are going to decide whether the witness is credible or the evidence presented is persuasive. It might even slow down the process. If you have to have 3 people at the trial court level reach consensus, it could take even longer.
Because the Utah State Bar testified against House Bill 392 during the initial committee hearings, I asked Wright to explain what authority the bar actually has in these debates and how it decides when to take a position on a bill. Under Utah's Constitution, the Supreme Court, not the legislature, regulates the practice of law, and the bar operates under that authority. Wright walked me through how that works and why the bar has been particularly active this session.
Yeah, so we have, it's interesting, the way we're set up, the Utah Supreme Court has exclusive constitutional authority to regulate the practice of law. It's written in the Constitution. And to that end, they've created the Utah State Bar, and our role among them is in regulating the practice of law. They have the ultimate say over all our rules, who's admitted, who's disbarred, but we administer that. We give the bar exam. We investigate lawyers who are accused of wrongdoing. We license lawyers every year. We maintain a list for the public of licensed lawyers. But the Supreme Court has delegated other duties to us as well as part of their obligation to regulate the practice of law. And one of those is for us to represent the bar in legislative matters, to support lawyers in their practice, to educate the public about the rule of law and their rights before the courts, to help people access the courts. So we have a pretty large constitutional role delegated from the court. And part of that appearing before legislative bodies, there are restrictions on what we can say before legislative bodies. We can only take positions on issues that affect the regulation of the practice of law, the administration of the courts, and access to the courts. So, for instance, we can't go up there and talk about salaries for school teachers or something like that, right? That's not our lane. That's not our purpose. And we are very careful about only speaking about on those three types of issues. And so we have what is called a Governmental Relations Committee. We have 39 practice sections. So like the real estate section, criminal section, family law, tax, litigation. Each of those sections has a representative on our Governmental Relations Committee. During the legislative session, the Governmental Relations Committee meets every Tuesday, and we go through bills that fit in those three areas that I described to you. And the Governmental Relations Committee makes a recommendation for us to oppose or support a bill, or we can take no position. And then in the afternoon on Tuesdays, the Board of Bar Commissioners, which is our body that oversees the bar, and the Board of Bar Commissioners are elected by all the lawyers in the state. They review the recommendations of the Governmental Relations Committee and decide whether or not we should oppose or support a bill. That is how we decide. It's quite a long, involved process with a lot of input and a lot of guardrails before the bar decides to take a position on a piece of legislation. And like I said, it has to involve those three areas: the regulation or practice of law, the administration of the courts, and access to them. So it's very limited, and we have a lot of guardrails. I will say we've been very involved upon the Hill lately because there has been so much of this legislation. Historically, I've worked at the bar since 2011, and we used to go up there and advocate for more funding for the courts, more funding for legal aid, and that was the end of it. Maybe one or two other issues came up, and now we're just up there so much because they are issuing so many bills that affect the courts.
Wright told me that the bar has been far more active on Capitol Hill than in past years, simply because the number of bills affecting the courts has surged. She said the volume alone has forced them to track proposals in ways that they never had to before.
Yes, yeah. I mean, the volume's been last year and then this year, we have to have spreadsheets and charts here to keep track of all the bills they are issuing that affect the court. And, with like real serious structural changes. So we've all been very busy.
As Wright put it, the sheer number of court-related bills this session has created pressure on the system. But with House Bill 392 specifically, she says the most immediate concern is fairness. The law gives the state powers in a lawsuit that the plaintiff doesn't have, and that imbalance could itself become the basis for future legal challenges. I asked her what that imbalance means in practice.
There are fairness and due process issues that might result in litigation. It'll be interesting to see if there are more changes to the bill to remedy that, because a lot of entities and people have raised that issue. Usually in a case, what applies to the plaintiff applies to the defendant, and there's the rules for each side have to be fair and the same, and you can't have one set of rules for one party and another set of rules for another party. It doesn't work that way. Has to be fair. Everybody has to have the same rights and obligations in a judicial proceeding.
Another concern raised by McPherson was the issue of frivolous lawsuits brought on by fringe groups like sovereign citizens. I asked Wright about that, and whether the law would actually change how courts deal with sovereign citizen or vexatious litigant cases.
Well, I don't know, because last I looked at the bill, it said this whole process would trigger if it was a case involving broad state interests or something like that. I I don't have it in front of me, but like something, there was a definition of the kind of cases, and frivolous litigants and sovereign citizen litigants, I don't know if that would apply to them. That's part of the system, is that it's the people's court and they're allowed to file. Sometimes there are unfounded lawsuits and frivolous lawsuits, and unfortunately, it's the nature of our system. And there are different ways, judges can determine that people are vexatious litigants, and after so many filings, and they can try to put limits on how they can file. But it is annoying. I'm sure the bar is frequently sued by some of these sovereign citizen groups. They believe that they have some natural right to be lawyers, and they will sue us for keeping them saying they aren't lawyers, kind of thing. It's unfortunate, but it seems to be a fact. And I'm sure the legislature is sued by these people all the time, too. But like I said, I don't know how this bill would solve the problem of those sovereign citizens or frivolous lawsuits.
When we talked about sovereign citizen filings, Wright said that the bar sees them from time to time, usually in the form of unauthorized practice complaints or lawsuits claiming a natural right to practice law. I asked her what those interactions actually look like in practice.
I don't know. I don't have any court data. I do know that the bar has been sued by these people. The bar also processes unauthorized practice of law complaints, and we occasionally get them against these sovereign citizen people who are practicing law. You send them a letter saying they have to stop, and then you get like a 90-page letter back explaining why they get to be lawyers.
I mean,
it's okay. No, I know.
Oh, geez. Anyway, that seems really out there. Okay, all right.
Yeah, they're around. I wouldn't know the volume of it in Utah offhand, but I have encountered them a couple times.
After that discussion, we'd return to the core issue behind House Bill 392, which is the difference between a state simply intervening in a case and a state being able to reshape the process itself. Intervention is normal. What's new, she said, is the idea that the government can redirect a case because it doesn't trust the judges who normally hear it. I asked her what that shift means for public confidence in the courts.
And I'm not deeply familiar with how that functions. Okay. I had never really thought about it until this bill came through and people have been talking about it. And again, I think it goes back to, sure, they can intervene, and they probably should. If something they're doing or a law they're passed is going to be declared unconstitutional, they should have a right to be part of the case. And again, that also exists in federal court. If there's going to be a decision that's going to affect your rights or the way you operate, you can intervene. That's a very common legal principle, policy, procedure, whatever you want to call it. I think this goes back to kind of picking the court and picking your procedure that they get. It's more than just intervening. Sure, they can intervene. Everybody understands that that's a good policy, but to think that I don't trust this judge that might be assigned to my case, again, it creates doubt in the capability or impartiality of the system. And then I get to pick this 3-panel because I think I'll get a better decision or a more fair result. It's very damaging to our system and to the citizens of Utah for them to all of a sudden think that not all judges are fair and impartial and not all judges apply the law the same way. And that therefore the legislature, who ironically appoints all these judges, confirms all these judges rather, all of it gets to have their own little procedure because they don't trust this one judge they might get in one district. It is very troubling and raises all sorts of doubts and lack of faith in our system.
With all these structural questions and fairness concerns, I asked Wright what would happen if someone eventually challenged House Bill 392 itself. She said that, like any constitutional dispute in Utah, the final word would rest with the state's highest court.
If there are grounds, and I'm not going to opine on this, but if there are grounds to challenge it on constitutional grounds, it will go before the Utah Supreme Court. They, by authority, have the ultimate say on interpreting our Constitution.
As we continued discussing the bill in detail, Wright kept returning to one practical issue, which is that the trial courts simply aren't built to function with a panel. They make sense on appeal where the facts are already settled. But at the trial level, where witnesses testify, objections are ruled on, and evidence is weighed, Utah has never used a multi-judge structure. I asked her what that would look like in practice.
Well, it's just one party being able to all of a sudden trigger a panel. And then, like I said, I don't know what they're thinking about how a 3-panel judge would conduct a hearing or a trial and hear witnesses and rule on objections. It's going to be unprecedented, I think. I don't know that we have any 3-panel district court judges. The appellate court judges, it's very common when they're just studying the law. But a district court judge has to conduct a trial. They have to conduct a hearing. They have to listen to witnesses. They have to wade through the exhibits and how to interpret the exhibits. I don't know how it's going to function just procedurally and how that makes it's strange and unnecessary.
Lawmakers say House Bill 392 is meant to stop forum shopping. However, the bill gives the state a way to move a case out of the venue where it would normally be filed. I asked Wright what that means for ordinary plaintiffs who file in the districts where they live or where the dispute actually took place.
You're harkening back to my law school days about so the rules of civil procedure. But it seems to me that this allows them to forum shop. If I'm Joe Citizen believing that this law is unconstitutional, any law that the legislature has passed is unconstitutional, and I live in Salt Lake City, and it's close to where I live, or my business is in Salt Lake City. The legislature is based in Salt Lake City, so I'm going to sue in Salt Lake City. And that's usually the way it happens. Forum has to do with where the parties are located. So this allows them to say, no, we don't want to be in Salt Lake City. We don't trust these Salt Lake City judges. We want a judge from San Pete to hear our case. We want a judge from Logan, and they get to forum shop. They get to trigger this 3-panel in hopes of having a different judge hear their case. That's the forum shopping.
So this bill, you say, would do the exact opposite of eliminate forum shopping.
Yes, correct. It allows them to forum shop.
By the time we reached the end of the interview, I told Wright that House Bill 392 is a highly technical bill. It changes where cases are heard, how appeals work, and creates procedures the Utah courts have never used before. Even after looking into it for a while, I realized there were parts of it I still didn't understand. Now, to his credit, Representative McPherson explained in his email to me the areas where he has relevant experience, and he expressed confidence in the parts of the process he knows. My next question to Wright was about the drafting of the bill itself. When legislation makes changes of this magnitude to how courts operate, how important is formal legal training in writing it?
I think it's really important. And for that reason, the legislature, they have a law firm up there called the Office of Legislative Research, and it's staffed by a whole bunch of lawyers employed by the legislature. And they are supposed to do the legal research and assist legislators in writing bills that comply with laws and Constitution and to help them. I mean, they employ a law firm to help them. And then the other thing that happens is bring stakeholders to the table. Part of what we've seen this session, which is extremely frustrating as a citizen and as a stakeholder, is that they lob out extremely flawed legislation. The next thing you know, this constitutional court was issued on Tuesday, this bill. It's really lengthy. We didn't see it until like the Wednesday. It was going to committee. And it was going to a committee. It didn't even go to the Judiciary Committee. It went to some House Rules Committee. And then over the course of the next 3 weeks, they keep making amendments to it, and they keep making amendments to it, and they keep changing it. And you have to keep track of it, and you have to keep going up to the Hill to figure out which committee it's in. And I'm like, and this has happened with a couple of other bills. Today, there's a bill that came out that requires video recording in the state courts on every single case, and they just lobbed it out there, and everybody lost their minds yesterday for all the reasons you don't want live streaming of trial court cases. And then today they've pulled it back, and they're going to make changes, and they've assured everybody there's going to be changes. And this is so frustrating. Why don't over the summer or during the interim Why don't they say, this is our goal, we think this is the problem, and then bring all the stakeholders, the lawyers who actually practice before the courts, their own lawyers at legislative research, the administrative body of the courts who can opine about the cost and the feasibility and all the issues, and let's work it out. What are your issues? What are you looking at with this 3-panel thing? Instead of just springing this legislation on us the day before it's going before some unusual committee, why don't we all sit down and talk about it? And we want the expertise. And it's not just legal bills, it's every kind of bills. If you're going to change anything in our state, water, education, I don't know, it's endless, everything they have to deal with. They have a big job up there. You bring the experts in and you listen to experts, and they just don't seem to be doing that this year. They just have people lobbying out these bills that are extremely flawed and raise all kinds of constitutional red flags and practical problems and financial problems. I mean, this live streaming one they released today is going to cost millions of dollars, but there's no fiscal note attached. And as a citizen, like I said, and as a stakeholder, like, why can't we have adult conversations ahead of the session where all the stakeholders are brought to the table? And then while I'm on a rant here, I don't know if you remember Becky Lockhart. She was Speaker of the House, and whether or not you agree with her politically, one thing she did before she became the Speaker, the legislature had been issuing all these kinds of really wonky bills. They would pass a resolution saying that the United States should withdraw from the UN. And that's something the state of Utah has no authority to do, no role in, and we kind of became the laughing stock for this ridiculous piece of legislation. And Becky Lockhart went up there and she said, no, we're not going to have any more of this off-the-rails legislation. We have to plan, we have to stay in our lane, and we have to be thoughtful about this legislation. And one of the things she required was a constitutional note on every bill. It had to go through ledge research, and they had to make a finding of whether it was constitutional or not. And it was on every bill. And they have stopped doing that. And we have asked them, why don't you have a constitutional finding by ledge research anymore? And they're like, well, we don't know. We just didn't want that out there publicly. Maybe somebody could sue us if we had that there. Or we have private conversations with them, and they've stopped doing that. And I think if Becky Lockhart were alive today, she might be a little ticked off at some of these bills that go out and have potential constitutional problems or feasibility problems. And they should bring their lawyers and other lawyers and other people who want to be involved. They should bring them to the table. And sometimes they do, and it's great. Sometimes they will call the bar. Representative Lubay passed some really good unauthorized practice of law legislation this year, and he called the bar first thing. And what are the problems? We worked with him over the summer in developing the legislation, and it's great. And I think they need to do more of that.
In the course of discussing the importance of legal training, Wright pointed to a recent example where a lawmaker spent years working with lawyers, judges, and other stakeholders before introducing a major change to Utah's court system. She said that kind of deliberate, collaborative approach stands in sharp contrast to how some of this session's court-related bills have been handled.
A couple of years ago, Senator Brammer created the Business and Chancery Court to hear business cases in the state of Utah. And the idea was he wanted to make Utah more friendly for business and to have a really qualified judge with some business litigation background sit on that court and to have some written opinions. It was a 2-year process for him to develop this court. And he presented to the bar. He came to our fall forum. He asked lawyers from our litigation section to sit on his planning committee. And he had all of these stakeholders at the table in the lead up to the development of this Business and Chancery Court. And it's passed. It's been up and running for 2 years. Judge Rita Cornish was appointed as the judge. She's highly qualified and capable judge, and happy ending. And that's the way it should be done. Bring the stakeholders to the table. Get everybody's input. And they know how to do that. It's just sometimes they just want to spring this legislation and get it out there and see what sticks to the wall.
Across this conversation, one theme kept coming up: House Bill 392 introduces procedures Utah's courts haven't used before, and it raises questions about how those changes will function in practice. Wright described the bill as part of a broader pattern this session, with several court-related proposals moving quickly and undergoing multiple revisions as concerns surfaced. Utah has also seen examples of major court changes developed over longer periods, with input from people who work within the court system before a bill is introduced. House Bill 392 is now law, and its effects will appear as cases move forward. The court's interpretation of the law will take shape through the decisions that follow. This is Jacob Rueda with TheLine.Info. Thanks for listening, and be sure to share, like, follow, and subscribe to TheLine.Info's YouTube channel and social media profiles. Until next time.